which is the host for this particular conference. About 15 years ago, when I was teaching a course on national security law here at Duke, I had sort of a dream. And the dream was that there could be a center here which could expand the type of studies that I was conducting and could be a vehicle for conferences, for research, for attracting people to the field of national security law. Because in teaching national security law, I'd become increasingly aware of a great number of issues that I was not aware of before. We had a precedent. The Center on National Security Law at University of Virginia, where my former student, John Norton Moore, had something underway that was of great significance. And I felt sure that that center would cooperate with us in getting underway. I pursued the dream. I got encouragement from colleagues here at Duke. I remember particularly Ken Pye, who was still here at that particular point. Various members of the faculty indicated their willingness to cooperate. Fortunately, the dream appealed to my mother, and her estate provided us some funding. The most important thing was to get the right man to head up the center. And fortunately, for a number of years, I had known a gentleman who had served in a very distinguished way in the Air Force, and whose name was Scott Silliman. And I was able to persuade him when he retired to return to North Carolina, where he had gone to college and law school, albeit at an institution about 12 miles from here. So he had many ties with the area and had extraordinary knowledge of some of the issues of national security law. And thanks to Scott, we got underway. We established a close relationship with the American Bar Association and its Committee on National Security Law. And we have co-sponsored a number of conferences with them in Washington, along with the University of Virginia Center on National Security Law. For about 7 or 8 years, we have had conferences in the spring here at the Duke Law School. Well, I'll say at the Duke Law School. We're a block away. We're here at this wonderful Washington Duke Inn. And we've attracted an increasing number of participants, some outstanding scholars, some leading diplomats, of course, members of our faculty and faculties from other schools in the area. And about a year or two ago, we were able to draw into the picture some other groups that were interested in this general subject matter of national security law. Today, I think we are beginning an extraordinarily significant conference. Its significance is obviously enhanced by the events of 9/11, which had such an impact on all of us and will continue to have such an impact. Exactly what direction we're going in, no one can be sure of, but at least through this conference, we may get some better directions, we may better identify issues, and hopefully we can better identify solutions. I think it was Ted Beamer who said, "Let's roll." That was on 9/11, and I think I'm going to say the same thing. I understand, by the way, there's a suit for copyright infringement from use of that phrase, but despite any liability I might incur, I'm going to say, let's roll, and I'm going to introduce our distinguished Dean, Kate Bartlett. Kate?
Thank you, Judge Everett. I want to add my welcome to Judge Everett's, and glad to see you all here today. As many of you know, it's been over a decade now that the Center on Law, Ethics, and National Security has been at the forefront of national and international conversations about policy matters involving military and national security issues. LENS is one of the centers about which we are most proud at Duke, and its achievements are clearly due to the organizational talents, the contacts, and the expertise of our two faculty leaders, Judge Everett, the man with a dream, and Scott Silliman, the man who helped him carry out this dream. LENS marks the intersection of two signature aspects of Duke and Duke Law School. First, its interdisciplinarity. I doubt there's any research university that produces more interdisciplinary activity than Duke. And this center epitomizes that commitment to true interdisciplinary research and teaching, as do the other Duke programs listed on your program that have sponsored this conference. It also represents Duke's grounding in international issues, an area, again, where Duke has been a leader, and this center represents the best of Duke. And I should also add, as a signature of Duke and this center, its sense of relevance. Year after year, LENS has the nose for the most important topics of the day and manages to attract the best experts and the best audiences to discuss the most difficult issues in those topics. This year is no exception. LENS being perfectly situated to address issues this year that have challenged this country's national security in a way and on a scale that just last year at this time no one could have anticipated. This conference has an incredible cast, called together by an incredible center, led by an incredible team of Duke professors, supported by an incredible set of co-sponsors, all set to go on an incredible program. Thank you, Robbie and Scott, for all your hard work putting this together. Thank you all for coming. Let's roll.
Allow me to add my welcome to Judge Everett and Dean Bartlett. I'm Scott Silliman, and I want to just make a few comments before we start our first panel. It might seem trite to say that much has changed since September 11th, the horrific events of September 11th. But if we recall, it was exactly 7 months today. Matter of fact, 7 months today, almost to the hour, when the plane struck the World Trade Center. That event has had profound effects upon our law, upon our policy, and upon how we examine our ethical values. There have been other conferences, other gatherings, other programs that have probed the consequences of September 11th. But each one, I think, has done so within the concept of a specific disciplinary perspective. What we have tried to do today and tomorrow is to give these issues an interdisciplinary look, seeking the nexus between law, ethics, and policy. In that respect, we believe we're unique in what we're about to do. I'd like to just mention a few administrative comments to you. If you have any questions whatsoever while you're with us, or if there's anything that we can do to assist you, to make your stay with us more enjoyable, more profitable, Heather McAllister, our center staff assistant, is out front with Patty Meyer. Please make any requests known to them, and we'll see if we can assist you in any way possible. I've asked all the 5 panel moderators to ensure that we leave more than enough time, at least 20 to 25 minutes at the end of each panel, for questions and answers and comments from the floor. I would ask you but one thing, that we have a wireless mic. We are videotaping this particular proceeding, and we also have the media represented, both in the print media and the television media will be with us on and off throughout the conference. And so if you have a question of any of the panelists or of any of our guest speakers at the meals, please stand and wait for Brian McAllister to bring you the wireless microphone, and then identify yourself and speak as loudly as you can. Lastly, in your folders, there's an evaluation form. Each year, we try to do a better job with these conferences, not only as far as Dean Bartlett suggested, choosing the the issue that is most topical and is of most interest to you and this community, but also to make sure that the procedure that we follow, the style in which these conferences are carried out, is the best. So we earnestly solicit your comments on those evaluation forms. We do look at them and we try to modify from year to year to incorporate your suggestions. So, without further ado, let me invite the members of our first panel forward, and we'll start the conference off with our first panel. Gentlemen? Our first panel this morning deals with use of force against terrorism, typically talking about use of military force. If we were to look back to a few hours after the attacks on the World Trade Center and the Pentagon, we would find that the administration and the press were talking about crimes of terrorism, crimes of terrorism. Our frame of reference was the initial bombings of the World Trade Center in 1993, as well as the bombings of our embassies in Kenya and Tanzania in 1998, both of which you recall were dealt with in the context of violations of criminal law. But later on the evening of September 11th, President Bush and other members of the administration started to talk in terms of acts of war. And then the following morning, all of us woke up to the headlines and the announcements that we were in a war against terrorism. That phrase, war against terrorism, was trumpeted across the headlines of our newspapers and used, as many of you know, as a backdrop for television news programs. But what kind of a war are we in? And what rules apply in this war? The law of war, which, as many of you know, is a subset of international law, has traditionally been enunciated in terms of interstate conflicts, interstate relationships with and obligations to other states. Because of the focus of the armed response of the United States and others, the focus being Al-Qaeda and members of the Taliban, these are non-state actors. And the question immediately arises as to what law applies. Does the international law apply? Does the Hague Convention regulations apply? Do the Geneva Conventions apply? Do the additional protocols of 1977 apply? The United States, for its part, has openly declared as a part of its Department of Defense policy that it will apply the law of war regardless of how a conflict is characterized. We will apply the law of war regardless of how a conflict is characterized. But if we have questions about how much of the law and what parts of the law apply, we also have secondary questions. What are the ethical values to be applied in a conflict against terrorism? If we try to adhere to the moral high ground in how we conduct our military operations, do we then become vulnerable to an enemy who openly denies the rule of law and chooses to use whatever method it can against us? The targeting of civilians, the using of civilians as shields, which are clearly violations of the traditional international law. Also, and I might add something, I got embroiled in a controversy with the press over, what do we do when we capture an Abu Zubaydah and we are attempting to extract the information from it? Do we use the traditional type of interrogation techniques that we are familiar with? Or do we, in a thirst for information about further threats to this country, do we resort to other means and perhaps even torture? And what are the ethical values and questions and issues involved in that decision? Lastly, notwithstanding the legal and the ethical considerations, does our use of military force against terrorism, Does it make sense from a policy perspective? Can we win a war against terrorism with the use of military force? Or should diplomacy be used exclusively, or perhaps a combination of the two? Do we lose more from a policy perspective than we gain through our current course? I suggest these are just some of the questions implicit in this whole issue of the use of force against terrorism. And joining me today is a distinguished panel of experts to discuss those and many other issues. Our first speaker is going to be Professor Chris Greenwood from the London School of Economics and Political Science. Professor Greenwood read law at Magdalene College in Cambridge, where he obtained his MA and LLB degrees. He served as a university lecturer in law and a fellow and tutor of Magdalene College until 1996, when he assumed his current teaching position at the London School of Economics and Political Science. Chris is a prolific writer, and he is currently completing a book entitled The Modern Law of Armed Conflict, extremely apropos of our panel discussion. He also serves as joint editor of the International Law Reports. Apart from his teaching and writing accomplishments, Professor Greenwood has practiced law as a barrister for the last 17 years, being appointed Queen's Counsel just 3 years ago. He has appeared as counsel on the International Court of Justice in the Lockerbie case and the case on the use of force in Kosovo, and also as counsel in the English court case involving the extradition of Pinochet. Our second speaker is Dr. Joel Rosenthal. Joel is the president of the Carnegie Council on Ethics and International Affairs in New York. He received his BA from Harvard in 1982 and his PhD from Yale in 1988. As with all three of our speakers, Dr. Rosenthal is a prolific writer, having authored the book Righteous Realists and several pieces, lengthy pieces, on morality and our foreign policy. He has 2 manuscripts currently in progress, one entitled A New Moral Climate for the Use of Force, and the other being America, the Moral Nation. And he continues to serve as editor of the journal Ethics and International Affairs. Joel is affiliated on the board of many organizations, and I've had the privilege of collaborating with Dr. Rosenthal on a conference last August in Newport on a similar subject, and Joel and I and Al Pierce are currently looking at another program for next year and collaborating again on the same area of the use of force and the ethics and morality of the law of war. Our final speaker is no stranger to those of us here at Duke University. He is Bruce Jentleson, the director of the Terry Sanford Institute of Public Policy and a professor of public policy and political science. Professor Jentleson received his bachelor's degree from Cornell, a master's degree from the London School of Economics and Political Science, and a PhD from Cornell. He was the recipient of the American Political Science Association's Harold D. Lasswell Award for his doctoral dissertation. Prior to coming to Duke, Bruce was at the University of California, Davis, where besides being a professor of political science on the faculty, he was also the director of the University of California, Davis Washington Center and Washington Research Director of the University of California Institute on Global Conflict and Resolution. Global Conflict and Cooperation. In 1999, for a year, he served as Senior Foreign Policy Advisor to Vice President Al Gore and the Gore-Lieberman presidential campaign. He's written 7 books and numerous articles, and if I were to go on to describe Bruce's accomplishments, I'd probably run out of time for the rest of the panel, so I'll stop with that. I don't think we could have assembled 3 more distinguished panelists, 3 more knowledgeable panelists in their respective fields of law, ethics, and policy for our opening panel of the conference this morning. So without further ado, Chris, let me turn the podium over to you, sir.
Thank you very much, Mr. Chairman, Judge Everett. May I begin just by thanking you for inviting me back to Duke and to the Washington Duke Inn. there's something quite extraordinary about this place, that within about 5 minutes of leaving the airport, I felt as though I was coming home. It's really one of the most welcoming institutions and environments that it's possible to come to, and I'm very grateful to have the opportunity to be back. And to be back and taking part in a panel where you bring together law, ethics and politics, the faith, hope and charity of foreign policy analysis. But I'm not going to tell you which is which. My task today is to look at the international law issues, and I'm going to concentrate on those, and in particular to focus fairly obviously on the legal issues arising out of the use of force following the events of the 11th of September. But obviously, if you pick up any newspaper today, you'll see that it's not the 11th of September, but the current situation in the Middle East, which is the dominant foreign policy story. And obviously, what I say about the use of force against terrorism necessarily has repercussions in connection with the Middle East, and I'm going to try and deal with those as I go along. Now let's take as our starting point a very simple and straightforward proposition. International terrorism is the clearest possible violation of international law. There's no doubt whatever that international law prohibits terrorist acts. It's true that there is no clear definition of terrorism in international law. But let's not be seduced by the lack of a definition into falling for that old adage that one man's terrorist is another man's freedom fighter. That's not only nonsense, it's one of the most pernicious pieces of nonsense ever to be given credence in university circles. Because you can tell what constitutes terrorist behaviour. And it needs to be said very clearly that the attack on the World Trade Center and the Pentagon, blowing up a group of elderly Jews celebrating the Passover, or for that matter, blowing up the British administration in the King David Hotel in Jerusalem in 1946, is terrorism. And it doesn't become any less an act of terrorism because you sympathise with the goals of those carrying it out. It's the nature of the act, not the motives which inspire it, which define something as terrorist. There are also very clear duties on the part of states in respect of terrorism. States are prohibited from engaging in terrorist activity themselves, a point of particular importance in connection with the Lockerbie dispute. But they are also required not to allow their territory to be used as a springboard for terrorist attacks upon others. A state has a positive obligation under international law to take whatever steps are open to it to prevent its territory from being used as a base for terrorist operations by non-state actors. The second starting point is that, as you said, Mr. Chairman, the attack on the World Trade Center and the Pentagon was a criminal act, criminal under United States law and criminal under public international law. If the International Criminal Court, which I believe will get its 60th ratification today, so the court will be up and running in the course of this summer. If the International Criminal Court had been in existence prior to the 11th of September, in my view, those who perpetrated that outrage, that is to say those who survived having perpetrated that outrage, are guilty of crimes against humanity falling within the jurisdiction of that court. But although these are criminal acts, it is, in my opinion, folly to see that as somehow excluding the law relating to the use of force. The fact that something is a crime, for which if you can catch the perpetrators you hold a trial, is not a factor which excludes the idea of taking military action to protect your own people in the face of attacks of the kind that we saw last year. And I think it's one of the failings of international law, perhaps of lawyers more generally, that we sometimes tend to think in a series of watertight compartments. And having put a particular problem into compartment A, we find it impossible to see how it could possibly have a repercussion anywhere else. An article by Judge Kasese, formerly president of the International Criminal Tribunal for Yugoslavia, writing about the events of the 11th of September, is entitled "Terrorism is also disrupting some important categories of international law." Well, two comments on that, much as I like and revere Lino Gisese. The first is that I think that if you were to go out into the street, come across any non-lawyer, and read out that title, they would think that you were mad. Nobody would think of terrorism as primarily something which disrupts important categories of international law. And secondly, there is nothing in the history of international law or in the underlying policies and values which it serves that says that if you can bring someone to trial, then that's it. You've got to approach the whole matter as a policing investigation and nothing more. The Nuremberg trials were possible precisely because of World War II. They weren't an alternative to the Second World War. Now, what I want to do this morning is to look at three principal issues. First of all, the law relating to the legality of resorting to force. Was it lawful for the United States to take military action in Afghanistan following the attack on the World Trade Center? Secondly, to say something about the application here of the law of war, which you referred to, Mr. Chairman. The law regulating the way in which force is used. And in that context, to make a few comments about the detention of prisoners at Guantanamo Bay. And lastly, just to make a brief comment about the role and relevance of the law in circumstances of this kind. Now, if we look first of all at the question whether it was lawful to resort to force, I don't myself find references to a war against terrorism particularly helpful. The concept of war is a technical one, it refers to a state of affairs between states, and it's hardly ever used even in that context today. I think it obscures more than it clarifies. A war against terrorism, in my opinion, is rather like talking about a war against drugs. It's good political rhetoric, but it doesn't begin to describe the legal scenario. What I think is more useful is to look at two other concepts. That of a threat to the peace under Article 39 of the United Nations Charter, which gives the Security Council the power to take enforcement action, and the concept of armed attack under Article 51 of the Charter, which triggers the right of national self-defence. Now, there's little doubt that international terrorism constitutes a threat to international peace and security. The Security Council has consistently taken that view for the last 10 years, over the Lockerbie dispute, over the blowing up of a French airliner, the attacks on the embassies in Tanzania and Kenya, the attempted assassination of President Mubarak. There's a whole string of resolutions on specific cases and of more general statements by the Security Council and the General Assembly describing international terrorism in these terms. And so there is no doubt that the Security Council could have taken enforcement action in the aftermath of the 11th of September, and it did. In Resolution 1373, it required states to adopt a lengthy list of measures to suppress the financing of terrorism, to get at the means by which terrorist organisations function, to cooperate in respect of the extradition and prosecution of terrorists. It could have gone further and authorised military action, but it didn't do so. And in my opinion, any attempt to squeeze an authorisation for military action out of Resolution 1373 is misconceived. It wasn't intended to have that effect. The United States didn't ask for a Security Council mandate. So I think we can set that to one side. But with this caveat, particularly now we are talking about the possibility of military action against other states, going beyond Afghanistan, the possibility of Security Council authorization may be enormously important, both in widening the range of legal options and also in affording a degree of political support that avoids the United States and a few allies having to go it alone. The only legal justification which has been put forward for the military action in Afghanistan is in fact the right of self-defence preserved in Article 51 of the Charter. The right of self-defence which the Charter preserves if an armed attack occurs against a member state. The United Kingdom, for example, in its letter to the Security Council, explaining why our forces were taking part in the campaign in Afghanistan, said this, that force was being employed in exercise of the inherent right of individual and collective self-defence, recognised in Article 51 following the terrorist outrage of 11th September to avert the continuing threat of attacks from the same source. And the United States letter to the Security Council was in broadly similar terms. Now that defence raises four very important questions. Was the terrorist attack of the 11th of September an armed attack for the purposes of the right of self-defence? Secondly, if so, did that attack, or the threat of other attacks, legitimise the use of force against Al-Qaeda? Thirdly, more problematically, did it legitimise the use of force against Afghanistan? And lastly, did that use of force meet the criterion of proportionality? Now, a few brief words about each of those. In respect of whether the attack on the World Trade Center and the Pentagon was an armed attack, the only real question here is whether you can have an armed attack from a non-state entity like Al-Qaeda. Had those aircraft hijacked and flown into the World Trade Center and the Pentagon by agents of a state, there's no question at all that it would have been an armed attack. The International Court of Justice has recognised as much in the Nicaragua judgment nearly 20 years ago. It seems to me that there is nothing in the Charter or the practice of international law which would limit the concept of armed attack to the use of force by states. In fact, if you go back to the classic instance of self-defense, which is still much cited more than 150 years later, the Caroline dispute between Britain and the USA, what you have there, and I do recommend to you an article in the 1938 American Journal of International Law by Sir Robert Jennings, which has an extraordinary capacity for foreseeing the type of disputes that we are now looking at. If you look at the Caroline dispute, what you had there was almost exactly what we are talking about today. Terrorism, only it wouldn't have been called that in those days, by a non-state group operating out of American territory against United Kingdom territory, which the United Kingdom responded to by cutting out the vessel Caroline in American waters and sending it to oblivion over Niagara Falls, unfortunately neglecting to remove all of the crew before doing so. The United States objected that this was an unlawful use of force. But eventually the US climbed down on that and accepted that where a state was the victim of an armed attack, where it was faced with an imminent threat of attack, it had a right to take action by way of self-defense. Well, that is exactly, on a smaller scale, what you have here. The use of force by a non-state actor. And of course, if you look at the reaction of the Security Council, the North Atlantic Council, the Organization of American States, all of those clearly treated the attack of the 11th of September as an armed attack for the purposes of the right of self-defense. And one last factor leads me to the same conclusion, and that's simple common sense. I think if you go out into the street, as we say in the English legal profession, if you go and find the man on the Clapham omnibus, if you can find an omnibus still running in Clapham, and you ask this hypothetical reasonable man, do you think that the right to defend the state against armed attacks only applies if the armed attacks come from the state, but it doesn't apply if the armed attack comes from Al-Qaeda or the Palestine Liberation Organization or the Provisional IRA? You'd think you were completely crazy. And as I've always told my students, if it looks as though the law leads you to a crazy result, 9 times out of 10, you've misunderstood the law. Now the second question then, if the attack of the 11th of September was an armed attack, does it give rise to a right of self-defense? Now here the problem is simple. The events of the 11th of September were over in a matter of a few hours. The right of self-defense is a right to resist an existing attack or a threat, not a right to retaliate for something that has gone before. The distinction between retaliation and self-defense is central to our ideas of international law and to the rule of law in international society. But again, I think if you look to the Caroline, you can see the way in which this has to be approached. The Attorney General advised the British government in the Caroline dispute, and I quote, "The grounds on which the conduct of the British authorities is justified is that it was absolutely necessary as a measure of precaution for the future and not as a measure of retaliation for the past. What has been done previously is only important as affording irresistible evidence of what would occur afterwards." In other words, the right to use force is not in response to the events of the 11th of September, but because the events of the 11th of September show that there is an imminent threat of future armed attacks coming from the same source, which indeed that source had bragged about the possibility of future attacks on the USA. And again, if you look at the British government's letter to the Security Council in October of last year, I think that point is very clearly made. So I have no difficulty with the idea that there was a right to use military force against Al-Qaeda. What about the right to use force in Afghanistan? Assuming for these purposes that the Taliban regime in Afghanistan, though it wasn't recognized, was in practice the government of Afghanistan at the time, but that it wasn't responsible for the Al-Qaeda attacks. Now that's questionable in the light of some of the documents that have come to light in the last few weeks. But let's assume, for the sake of this discussion, the Taliban was not directly responsible. One school of thought maintains that if a state cannot be sued for damages for a use of force, if it can't be held responsible in that sense, then a fortiori, it cannot open itself up to the risk of military action. Again, that seems to me to be far too technical and formalistic an approach. There is, I think, this analogy which may be helpful. A neutral state in time of war has an obligation not to allow belligerents to mount military operations from its territory. If it either cannot or will not prevent them from doing so, then the other belligerent party is entitled to take action to deal with the situation itself. That, I think, again, is precisely what you have here. At the very least, the Taliban tolerated Al-Qaeda's activities from its territory, allowed it to use the territory of the state of Afghanistan as a springboard for military operations. And it made clear that any military action against Al-Qaeda would be resisted by the Taliban's forces. That, I think, was sufficient to open the Taliban up to military action of the kind that we've seen. And lastly, what about the criteria of proportionality and necessity? Those, of course, are forward-looking concepts. It's not a matter of counting the number of dead in New York and asking, are there more dead bodies coming out of Kabul and Kandahar? What you have to do instead is to ask, is the use of force no more than is necessary to deal with the threat posed? And I think that that test is satisfied on the facts. Now, I said I'd make a brief comment about Israel. This is where I fear I do part company with some people in this country and with the present government of Israel. I quite accept that Israel has been the victim of an armed attack, that it has a right to use force in response. But in my opinion, what we've seen in the West Bank in the last couple of weeks goes beyond a forward-looking act of self-defense and has come to resemble old-fashioned retaliation and reprisals in a situation where there appears to be no long-term solution on offer at all. Now, I'm running short of time, so let me briefly comment on the other two issues that I've raised. The first is the application of the laws of war. I'm very glad, Mr. Chairman, that you made the point that I was going to make, that the United States Department of Defense, as a matter of policy, maintains that it will apply humanitarian law in any fighting in which it becomes involved. That must be right, even if technically hostilities between the United States forces and Al-Qaeda are not an international armed conflict. It cannot be lawful in a situation of that kind to do things you are prohibited from doing in the middle of a world war. It cannot be that the protection afforded to civilians by international law is less in a conflict of that kind than the protection afforded in an all-out war between, for example, NATO and the Warsaw Pact. But in fact, I think the matter's simpler than that. What you had in the last year was fighting between the American and Allied forces on the one hand, and the forces of Afghanistan on the other. That was an interstate conflict, quite separate from the internal conflict already taking place in Afghanistan. And the Geneva Conventions and the rules of customary humanitarian law applied to it. The protocols of 1977 wouldn't do so, because neither the USA nor Afghanistan are parties to them. Now that raises the question, of course, of what about the prisoners at Guantanamo Bay? There are two issues that arise about that. One is the question of their status, and the other that of their treatment. It's the second question which really matters. The first question is far less significant, and therefore it's perhaps not surprising that attention was focused almost exclusively on the less important first question than on the more important second one. As far as the status of the prisoners is concerned, I think it would be impossible to make a realistic case for saying that captured Al-Qaeda fighters were prisoners of war under the Geneva Convention. I don't think they come anywhere near meeting the criteria for prisoner of war status, which for an irregular group of this kind includes conducting operations in accordance with the laws and customs of war and distinguishing themselves from the civilian population, neither of which they've done. The case of the Taliban combatants is much more complicated. They, I think, you can reasonably refer to as regular armed forces of the state, although they might not look like anything we understand by that term. As members of the regular armed forces, if captured, they are presumed to be prisoners of war until the contrary is established. And I think it's a pity from this point of view that the United States did not follow through and set up a tribunal to determine their status under Article 5 of the Geneva Convention on Prisoners of War. But had it done so, I think it's highly likely that the vast majority of those held at Guantanamo Bay would have failed the test of prisoner of war status in any event. Because again, they made no effort to distinguish themselves from the civilian population. That, in my view, is fatal, even for members of regular armed forces. But the far more important point is their treatment. And the issue I want to stress there is that just because they are held at a naval base in Cuba doesn't mean that they are held in some kind of legal limbo. The rules of international law apply to them in any event. Whether the US Constitution does or not is something I'm not competent to speak about. And that means, as a minimum, that everyone detained is entitled to be treated in a humane fashion. For that reason, I think it's imperative to reject absolutely any suggestion that torture or inhuman treatment, or to use the rather appalling euphemism adopted by Shin Bet, rough handling, can be acceptable as a means of extracting information from them. Let me, as somebody who comes from a country that has lived with terrorism on its doorstep, that has seen the law courts in the middle of London blown up with heavy loss of life, just at the time I was qualifying as a lawyer, let me say that tempting as the use of torture is when you're facing a terrorist adversary, it is always devastating for the society that resorts to it. It is never the nice, straightforward case posed by the philosopher that if we know we have someone who's planted a bomb and we can torture him to find out where the bomb is, let's go ahead and do it. Within a matter of weeks, you torture people as a matter of routine. And that can never, ever be right as a matter of international law. Now, in his little book, just published, Warrior Politics, Robert Kaplan has suggested that international law really has nothing to do with this at all. He concludes, and I quote, "The moral basis of our foreign policy will depend upon the character of our nation and its leaders, not upon the absolutes of international law." It's always dangerous to disagree with someone as eminent as Robert Kaplan, but with respect, what he says is nonsense. The rule of law is part of what we are fighting for. If we lose sight of that in the fight against terrorism, then in my opinion, we might as well pack up anyway. Thank you all very much.
Judge Everett and Scott Silliman for including me on this panel. But I also want to thank the judge and Scott for making ethics part of your dream. When I started at the Carnegie Council, we were launching a journal called Ethics and International Affairs. And I can tell you it was a tough sell when I began. I would get quizzical looks. What could ethics possibly have to do with international affairs? I presume that lawyers sometimes get that same quizzical look when you talk about law and ethics. No, never, Chris. And it reminded me actually of when I was a student, a college student, and I went to France. And the father of the host family asked me a question, and he said, "What are you studying in college?" And I said, "History." And his eyes lit up. This was his favorite subject. He thought it was a very important subject. And he said, "Well, what part of history are you studying? What is your field of concentration within history?" And I said, "American history." And he just laughed. "It's so short. It's so short." That's how I sometimes feel when I'm trying to inject ethics into these discussions. And you can see that Scott has placed me smack in between, literally in between the lawyer and the policymaker, and I assume that he did that with good reason. So I'd like to think that what I have to say is inseparable from their analysis rather than an add-on. This isn't just ethics down the hall, this is ethics right in the center. And that's what I'm going to try to make happen in my comments. The situation we find ourselves in today reminds me of Isaiah Berlin's essay, The Hedgehog and the Fox. Berlin suggested we could divide the world into two types of thinkers, hedgehogs and foxes. Hedgehogs relate their experiences to a single central vision, one big idea. Foxes, on the other hand, see the world as centrifugal rather than centripetal, ideas going out rather than in. Let me suggest that we're all hedgehogs now. One big idea, the war on terrorism, seems to be the organizing principle for American foreign policy and beyond. Now, one big fact dominates our understanding of this one big idea. This war is characterized by asymmetry. Indeed, any relevant assumption of this new war begins with the premises of asymmetry. And I'll just tick off 4 examples for you. They're sort of self-evident. But we have states versus non-states, conventional forces versus non-conventional threats, old ideas of deterrence versus suicide bombers, professional soldiers trying their best to adhere to the laws of armed conflict against those who have no intention of adhering to those norms. So any policy analysis and planning must begin by acknowledging these fundamental empirical and normative asymmetries. It's imperative to understand that the asymmetry extends beyond just military capabilities. There is no universal acceptance of the values that many of us hold to be universal. So that said, where do we go from here? Now, I'll leave aside the empirical, factual implications of the situation I just outlined to comment on the normative or ethical issues. How should we think about the war on terrorism in terms of the nexus between law, ethics, and policy? I feel a little bit like George Kennan, who writes in the introduction to his book, American Diplomacy, and this is a quote from Kennan. "There are times in recent years when I found myself wishing that there were a bit more of morality in our concepts of what is legal, and more attention to legality in our concepts of what is moral." That's Kennan's book. In good times, law and ethics are in sync. Law codifies the ethical consensus of a political community. But I think these may not be such good times. There's always been a clash between the stipulations of international law and global treaties on one hand, and the subjective sense of morality which nations perceive as righteous and appropriate on the other. This new war on terrorism seems to be making this gap wider and more important. The United States today has an ambiguous relationship with international law. In many respects, the United States is a principal architect and engine of evolving international law. We see this in the constructive side. We see this constructive side in activities ranging from support of war crimes tribunals in The Hague to the promotion of international trade, labor, and environmental standards through instruments like NAFTA and the WTO. But in other respects, as the world's strongest military and economic power, the United States resists any trend that smacks of supranationalism. The U.S. retains an understandable desire to keep a free hand, to act unilaterally when necessary, and to avoid legal straitjackets that it perceives limit its options to protect its citizens, its soldiers, and its interests. The new war presents several moments of truth as the United States navigates between protecting its national interests and seeking to weave a stronger fabric of international law. We can break down these moments of truth into two sets of test cases, what we would call justice of war category and justice in war categories, going by the just war tradition. In deciding how to proceed in these cases where the law is not clear, will the United States interpret its interests strictly, narrowly, and materially? Or will the United States calculate its interests broadly, taking into account some of the moral principles traditionally associated with the rule of law? Now, Chris mentioned several, so I'll just tick them off quickly. In the justice of war category, there are several concerns. One is anticipatory self-defense. Will we push this concept to new limits in arguing for actions against Iraq, in addition to Al-Qaeda? We have the spectrum of deterrence, punishment, reprisal. How will the United States respond to the next terror attack? Will it insist on reprisals? What methods of deterrence are considered legitimate? Now, in the justice in war category, we have obvious concerns. Collateral damage. What sort of damage is considered acceptable in military campaigns against terrorists? How do you drain the swamp without killing everything in it? We have the question of nuclear weapons. What sort of weapons are legitimate in pursuing a war on terror? Detainees, Chris mentioned, what do we do with unlawful combatants? In this new era of asymmetry, how should we deal with those who show no reciprocity? So how will the United States align its moral values as they relate just war to the legal issues I've just raised? I do believe that we have to start with ethics. Ethics asks the question, how should we live? What is in the best interest of the human person? What is it that our society values? Let me refer to the book Warrior Politics that Chris mentioned. It's an interesting book. It has an interesting subtitle, too. This is the book by Robert Kaplan. It's called Warrior Politics, Why Political Leadership Demands a Pagan Ethos. Kaplan argues that we should be exceedingly careful in translating the questions that I just raised to a policy context, these questions of ethics. In today's climate of asymmetry, he argues, and this is a quote from Kaplan, our moral values are our greatest vulnerability. Our moral values are our greatest vulnerability. By this, he means to call attention to the fact that our values are not shared, that our values are in fact the target of our end. Does this mean that we ought to abandon or suspend those values for the purposes of this war? I think not, and I'm not sure that Kaplan thinks so either. What he does want us to consider, though, is that the best way to fulfill our moral aspirations may be to pursue our enlightened, rational self-interest. For Kaplan, and here is where I'd actually agree with him up to a point, the war on terrorism should not be seen as a war of good versus evil. Moral clarity is a virtue, but absolute moral certainty can be the road to ruin in politics. Moral clarity means that we have a clear and unambiguous conception of right and wrong, and that we defend that position with moral commitment and prudent judgment. But moral clarity also accepts the fact that others have moral commitments too, however wrong-headed and evil we think them to be. Now, a true statesman understands this tragic conception of politics. Lincoln understood that the Confederates acted in good faith, defending a way of life that they considered to be moral, just, and right. As he put it in the second inaugural, the quote from Lincoln you all know, both read the same Bible and pray to the same God, and each invokes his aid against the other. His with a capital H, meaning God. Each invokes his aid against the other. This understanding did not make Lincoln a moral relativist. He stuck to his position, again in his words in the second inaugural, with firmness in the right, as God gives me to see the right. Yet Lincoln's understanding of politics and human nature, that others have their own view of what is just and right, made him the great statesman that he was. It made him able to marshal and keep support and pursue an all-out war that could end with charity to all and malice toward none. Moral certainty and the language of good and evil are dangerous because they take politics out of the realm of interests and power and into the realm of absolutism. I happen to believe that there is evil in the world. And I do believe that evil should be met with the full force of ethics, law, and state power. In fact, my conception of politics begins with this recognition that evil is a fact of life. The question is, how do we confront it? How do we restrain others? And how do we restrain ourselves? So how do we make our moral values work for us rather than against us? I think the answer lies partly in recognizing the limits and dangers of our moralizing. It also lies in shifting our moral focus from our high-flown moral rhetoric to a concept based in enlightened self-interest, a concept nicely captured in Joseph Nye's notion of soft power. In the end, it is our moral values that we stand for that will distinguish us from our enemies. And here's where I get to law, which you can wait patiently. International law gives us a point of reckoning between the shoals of moral certainty on one hand, on one side, and moral relativism and moral equivalence on the other. I hope that the United States will engage it in good faith, with real commitment, as we face new tests in the war against terrorism. As we employ our hard power with great success and some justifiable pride, let us not neglect our strategic advantage on the soft power side. When I was in high school, a teacher said to me, "Look at your friends, and that's what you are." Right now, the nations that do not take international law seriously include the likes of Iraq, North Korea, and others. Not exactly the friends our parents would be proud of. The values represented by those who take international law seriously are the values that the United States should seek to promote. The United States will both protect its long-term interests and stand for positive values if it chooses to work energetically with the tide of evolving international law, rather than against it. I hope that gives you a good context for the connection between law and policy. Bruce will get that from me.
Thanks very much. I think there's a certain amount of complementarity between what I have to say and what my fellow panelists have. Maybe some differences, but I actually think that sometimes you want to get, sort of point counterpoint on panels. But I think here that it may there may be a reason why there's complementarity is one looks at these issues from perspectives that are primarily but not exclusively legal, primarily but not exclusively normative, and primarily but not exclusively in terms of policy. But I want to actually start before September 11th and step back a little bit and put this in the context, I think, of really as the post-Cold War context. When the decade of the 90s started out, I think we all can recall some of the sense of euphoria that characterized this period. The Cold War had ended without a nuclear war. The Berlin Wall had come down. There was no more Soviet Union. Nelson Mandela was the president of South Africa and many other aspects of euphoria, or at least out of jail at that point. The euphoria came quickly crashing down in places like Bosnia, Rwanda, Somalia, and elsewhere. And one of the basic truths that became very quickly evident was that the end of the Cold War did not mean the end of war. And indeed, it put the centrality of use of force questions right up there in the international agenda very early on in the post-Cold War era. And so as of September 10th, 2001, the United States and its policy, the United Nations and others in the international community were wrestling with many issues, but particularly with questions about the use of force. What was the best way to do peacekeeping? What was the best way to do preventive diplomacy? How did you achieve effective deterrence in many levels of conflict in the nature of the post-Cold War era? And then came September 11th, which has been said, in many respects, tried to be the defining issue of the post-Cold War era. And it was very understandable for everyone in the world, for Americans, for New Yorkers, not resident New Yorkers, but native New Yorkers like myself and others, were very traumatized by what happened. And for many months to feel that the entire focus of thinking about international affairs had to be in the context of the war on terrorism. But I think that the dilemma that we face is, in effect, how do you combine the September 11th agenda with what I often refer to as the September 10th agenda? Because those issues that were on the agenda, and we can speak about many things here, but even just thinking about those that raise use of force issues, didn't go away. They were superseded for a period of time, and understandably, for political, psychological, emotional, many reasons. But they're with us. And one of the manifestations of that was that on September 14th of this past year, there had been scheduled to be released the report that some of you may be familiar with of what was called the International Commission on Intervention in State Sovereignty. It was set up in September 2000 with a lot of support from the Canadian government, a number of American foundations, including Carnegie Corporation of New York, and blessed by the United Nations and chaired by Gareth Evans, the former Foreign Minister of Australia, and Mohammed Sinoon, very distinguished diplomat at the United Nations, to look at the issues that have been raised about questions of intervention and sovereignty as they've been playing out in what we refer to as ethnic and civil conflicts. They were mandated to release this report within the year. They were targeting September 14th. Well, obviously, they waited a few months to release it. And that report is out now, and I want to try to marry or bring together at least the questions posed by those conflicts as well as those posed by September 11th. Because one of the great debates in this country, I don't know if it was a great debate, but it sure was a political debate, was this notion of nation building, and did the past administration have its focus right, and the new administration was going to be highly geopolitical, focus on what often referred to as type A problems, and not those type C problems like Bosnia and Somalia and Rwanda. But one of the things that Afghanistan demonstrated is that type C problems could have type A effects. And so these agendas have come together very, very, very much. The argument I want to make, and very briefly in the interest of time, in a sketchy way, but come back to in your questions and discussion, in answer to Scott's questions about, is force effective and prudent? My answer is yes, it can be and needs to be. That military force is not the whole strategy when one thinks about the war on terrorism and when one thinks about ethnic and civil conflicts. But strategy cannot be whole without at least the credible threat of the use of military force. And I want to make that argument and relate it a little bit to what is sort of considered phase one of the war on terrorism, phase two, and also back to the agenda of the civil and ethnic conflicts. And three dimensions to it that play in: the normative dimension, the political dimension, and the policy dimension. Because in fact, I agree with my colleagues here, norms are a part of policy. They're not just feel-good stuff. There is indeed a realism to normative considerations, particularly in the post-Cold War era. That the nature of the era in which we live, for systemic and structural reasons, is one in which the normative legitimacy of actions when it comes to the use of force is a very important consideration. It's not just the soft stuff. It's not just feel-goodism. But to a great extent, it's part of being able to carry out effective policies. That to the extent that you don't have normative legitimacy, unlike the Cold War, where basically might could make for right, at least in a realpolitik sense, that a normative consideration has to have a realpolitik dimension, that it's not the antithetical sort of Wilsonian idealism versus notions of realpolitik and realism. That norms matter more, and that this is normal for the era in which we live. It's not an aberration, it's not woolly-headedness, it's not going to go away. And therefore one has to think of this in a policy context very much as well. So one looks, for example, at the war in Afghanistan, and it is my view, as someone who's not an international lawyer, I think that in some respects the question of the legitimacy and the legality of the use of force in Afghanistan was in some ways, I think, to normative issues the way that the Persian Gulf War of 1991 was to military strategy. It was a case from which it's going to be hard to generalize, because we had a number of conditions that came together for the military operation that was launched in October of 2001. I think there was a sense, at least, of a very clear and present danger from a U.S. perspective and the perspective for many Europeans and others in the world. And this made for a sense, I think, of some degree of shared threat and interest that brought nations together. It was against a government that had very little international legitimacy. And there was a strong liberationist claim to the interests of the Afghan people. Those are very hard conditions to replicate as one thinks about other situations in the international arena, be it phase 2 of the war, terrorism, or others. And in some ways it sets the threshold as a very high bar. And one of the dilemmas that one faces is not only was it legitimate to use force in Afghanistan, but what are the implications? And here my argument is that they don't extend all that far, because these 3 or 4 conditions are going to be very hard to replicate in the same way in other cases. The other part of the normative aspect that I think is extremely important that the International Commission on Intervention in State Sovereignty has been wrestling with is precisely the question of, they call it in that report, the responsibility to protect. I call it in a lot of work that I do, the debate between conceptions of sovereignty as the rights of states and the responsibilities of states. And if I can think of one fundamental issue that's been raised by ethnic and civil conflicts in the 90s that sets the stage for questions about effective strategies, it's very much this. What are the rights of the international community? Without even necessarily, you've then got to get to the who question. Is it only the United Nations, or is it the US or NATO and others? To intervene in situations in which the killing or the threats are being done on an intrastate basis rather than an interstate basis. When Saddam Hussein invaded Kuwait, it's a pretty clear case of tanks that crossed borders. It was a classic case of interstate aggression. But Milosevic in Bosnia, or Milosevic in Kosovo, or situations of Rwanda and even East Timor raised very difficult questions. And I think that one of the strengths of this report from the Evans-Senoun Commission, these commissions always have to sort of strike a balance between sort of political viability and policy validity. You know, you had a very broad-based UN-like group of commissioners, and how do you say something that everybody can sign on to without ending up as sort of plain vanilla and not having any policy validity? I think they actually did a pretty good job, because if you read the report both explicitly and in between the lines, they make a couple of arguments. One is they make a strong argument that sovereignty as responsibility really has some precedence over the rights of states. Not in all situations, and not as a blank check for the international community to get involved, but to fight against the notion that Article 2, Section 7 somehow protects states from any international intervention because they're only doing it within their own borders. Secondly, is they have a conception of the use of force that they refer to in the report, or what I sort of consider sort of an anticipatory sense of use of force, which is to say that the use of force can be legitimate not just as a last resort, not as a first resort, but often what one might consider to be an early resort. That the anticipatory notion argues that you don't have to go through the whole toolbook of instrumentalities, but if you can determine that those are going to fail, and if you combine that with conceptions of prevention, that it's not enough to just go in and pick up the pieces after 850,000 people have been killed in Rwanda, but that the goal is prevention from a lot of different perspectives, that there can be legitimate uses of force as an early resort in an anticipatory sense. And thirdly, they talk a lot about the importance of prevention as one of the perspectives that we need to do much better on. So I think the normative debate lays the groundwork. Norms do matter in international affairs. I think they matter even more in the context of the post-Cold War era than they may have mattered in earlier eras. In terms of the political dimension, and I just want to run through each dimension just quickly, there I think are 3 points here that I want to make, and here my focus is a little more US-centric. One is the argument is often made that, geez, we'd really like to do these things, but you know, the American public won't let us. I mean, after all, there's the Vietnam trauma, there's the 18 deaths in Somalia, and cutting and running. One of the largest myths in political science, in the policy world, and journalism is the myth of casualty voting. I've done a lot of work on this and have made a number of arguments going back a number of years to say that it's simply not the case, that the American public, you know, came out of its Vietnam trauma during the 80s, and indeed has been distinguishing between situations in which it's prepared to support the use of force and which it's not. That nobody wants casualties, but that the degree of tolerance for casualties varies with a sense of what are the principal objectives being pursued. To the extent that those objectives are to restrain aggression, that the public is much more likely to support it than it has been when it's simply to try to get involved in civil wars. And so in some ways it was no surprise in the wake of September 11th to see the high levels of public support for the use of force. Indeed, if you go back to Kosovo, the American public was prepared to support the use of force, including ground troops, in ways that the Clinton administration was not. I was part of the administration. Part of one of my positions in the administration back in 93, 94 was on the policy planning staff as special assistant to the director. And I was there during Somalia. And I was always struck by what happened, you know, in October 93, in which, frankly, the president got on television and he said, you know, we lost these lives, it's a terrible thing, the mission changed. It's a wonderful construction. It was a third-person, non-possessive construction. That the mission was something that got up in the middle of the night, flipped itself over, and changed itself. You know, and it was perfectly rational for the American public to say, I'm not hearing that we know what we're doing there. I'm not hearing we have a strategy. It wasn't trauma, it wasn't irrationality, emotionality. It was perfectly rational to say, let's get out. A lot of studies showed at the time that had the president gotten on television and said, here's why we're there, here's what we're doing, he obviously should have done this sooner, here's how we're going to complete the mission. And in the same way, back in 1968, many of the people in New Hampshire that voted for Gene McCarthy actually thought he wanted to escalate, not just de-escalate. There would have been a degree of public support. The public is pretty prudent. It distinguishes between situations in which it thinks the objectives are worth it and in which it believes its administration has a strategy. It is not saying, fine, let's lose casualties, that would be wrong on any count. But the notion that the constraint of public opinion is a fixed constraint that presidents face has been flawed for the last 10 to 15 years. It's a malleable constraint that's open to argumentation. Secondly, as a part of that is the so-called CNN effect. And here too, there's a lot of literature. Let me just simply summarize it in one point. You know, support goes up when we see the starving people in Somalia, and it goes down when we see the violence. A lot of very careful analysis of the effect of media on public opinion in this country has shown two things. One, that the greatest effect of the media is in framing the agenda, putting issues on the agenda, like starvation in Somalia. There was a tree falling in the woods until we began to see it, indeed on NBC, not just CNN. But secondly, it doesn't have that tremendous effect on what people think about the issues. It only has an effect in situations in which an administration has not effectively used its bully pulpit to get its own case out there. And in Bosnia and Somalia, again, to be critical of an administration that I was a part of, there was a very mixed message in terms of why we were there, what we were doing. And so the CNN effect is also not something that ties the hands of presidents. It's something that has to be dealt with, but doesn't tie the hands. The last point about the politics is with the current debate, and it's really a great concern of mine. We have a tendency in this country to have a very narrow parameter of what's the legitimate scope of political debate. The three most dangerous words for politicians often are soft on fill in the blank. And so during the Cold War, it was soft on communism. And there were any number of periods during the Cold War. Winston Churchill, after the death of Stalin, you know, not exactly someone who didn't take the Cold War seriously, you know, was looking for, was talking to the possibilities of rapprochement and exploring de-Stalinization and the like. There could be no debate in this country because we were living through the legacy of McCarthyism. In the current debate of the war on terrorism, when in late February, Senator Daschle says, you know, I have some questions about the president's policy. And Senator Lott responds, how dare Senator Daschle question the president's policy? I would have had no problem if Senator Lott said, I think Senator Daschle is really stupid, and these and these and these are the reasons why his ideas are wrong policy. I had a lot of problem with the notion of how dare. And we as a country on a lot of these issues have to figure out how to have a debate that may even be about right threat, wrong strategy. And we have had difficulty with that many times in our past, and it's very important that we be able to do that in this particular case. And here I get to the, just some comments on the policy aspects. Again, as I said at the outset, my view is that strategy in the war on terrorism cannot be whole without a military peace, but the military peace is not the whole strategy. And I say that in a couple of different respects. One, there's no question that a certain amount of military action was necessary and continues to be necessary to defeat and destroy and take apart the terrorist network and dealing with those who basically will resort to terrorism. If you imagine that the Camp David Accords of 2000 had been completed successfully, and you ask yourself the question, would the attacks on the World Trade Center still happen? I think to me the answer is pretty much unequivocally yes. It relates to the current Middle East conflict, in which there's a whole lot of aspects to that, but it's also important to remember that we've seen terrorism in the Israeli-Palestinian context often when the peace process has been going well, not just when it was going bad. In 95, 96, when it was going well, right before the most recent Zinni mission, Hamas basically said, we basically want to make sure this fails. You know, when the train is headed towards a positive direction, there are efforts to blow up the tracks. And so I think that there is an aspect to this that you simply have to use military force to deal with. You also need, and arguably in some ways more importantly, other aspects of coercion. Intelligence sharing, taking apart the economic and financial networks, border security, law enforcement cooperation. One of the dilemmas the U.S. faces, I think, in being overly unilateral in some of our approaches, which may get into questions about Iraq, is the risk of losing the pretty effective multilateral cooperation we're getting from the Europeans and many of the Arab world now on some of these other issues, you know, which are extremely important in winning the war on terrorism. So there's a lot of aspects to this that are coercive, military, and not. But secondly, as we move into this next phase of it, I see some very disturbing analogies between the early parts of the Cold War in terms of the globalization and the militarization of the commitments we're starting to make around the world in the name of the war on terrorism. It's only 100, 150 troops in the Philippines, or in Yemen, or in Georgia, or in other parts of Asia. What do we do if that doesn't work? I've actually been working on a piece trying to draw a little bit of an analogy between where we are now and NSC 68, which some of you may remember. It's not enough to say that we have a limited mission. Not only do we have to deal with issues within that about how do we try effectively to work with the militaries to get at the cells of Al-Qaeda, without getting on the wrong side of the political issues of some of the issues that make these governments unpopular. But we're going into a phase of globalization and militarization of the war on terrorism on a broad scale that requires serious debate. It's not as self-evident as the military operation, I think, in Afghanistan started in early October. Secondly is, what about winning the peace? We tend to be a little better at winning the wars than we are winning the peace. And again, we have to win the war. This is not a juxtaposition of diplomacy, cultural understanding versus the military side. The military piece is necessary for the strategy to be whole. But winning the peace is much broader than that. And it's not simply throwing a Marshall Plan at the Middle East. I mean, we've had Marshall Plans for every part of the world invoked. The Marshall Plan worked in Europe for certain particular reasons, and those aren't necessarily replicated. But it is, and it's not a simple relationship between economic inequality and poverty and violence. Indeed, with this particular group of perpetrators of terrorism, it's even more interesting because it's more about disaffection and alienation than, at least in terms of the World Trade Center operations. But there needs to be an effort to win the peace. That's a battle of ideas in the Islamic world about the nature of Islamism in a context that can deal with the grievances against Israel, the United States, and others, but doesn't necessarily lead to support for terrorism. It poses difficult questions for the United States in terms of our relationship with many key countries in the Arab world. And it does relate to issues over the long haul about how do we invest today in some of these issues. Well, we're thinking, we need to think in short, medium, and long-term time frames. The short time frame is really about winning the war. The medium time frame is a part about that. It's also about winning the peace, and so is the long term. So that when the long term becomes the short term, we've tried to do some things to reduce sort of the feeder process for terrorism. That brings me back to the other issue, and I'll end on this, which is these same questions could be applied to the question of civil and ethnic conflicts as they deal around the world. The world really needs to have a strategy that deals more effectively with these in a preventive way. Some of this is about conflict prevention in the broad terms of structural senses, as the Carnegie Commission on Preventing Deadly Conflict put it. But it's also going to be about, and this latest report by the Evans-Senoon Commission supports this, ways to credibly create military capabilities that send messages to the likes of Milosevic that can have more of a deterrent effect and at an early stage more of a coercive effect to stop these issues from moving forward to where they've gone. So the normative, the political, and the strategy dimensions all come together in trying to figure out what effective policies will be as we look to the future. I think the challenges are even harder for us than they've been for this last 6 months or so since September 11th. Thanks very much.
Thank you, Bruce. Before I open it up to questions from the floor, I would pose one question to all three of you. Chris, you indicated that international law clearly does support the use of force, and as long as there is a demonstrable continuing threat, I think you suggest that the use of force is still appropriate under international law. Joel, you indicated that the use of force against evil is appropriate, and we must not fall prey to this concept of the moral high ground becoming our vulnerability. And Ruth, I think you stated very clearly that military force, use of force, is a clear component of strategy. Not the only one, but a clear component. Now, I would ask you this. If in fact we all agree that the use of force so far has been legitimate, ethical, and in accordance with sound policy, when do we say the war is over? Because the question becomes, if terrorism exists anywhere in the world, does this predicate of the use of force continue to be available, and should it be available? Chris?
Well, I think this is one of the reasons why I dislike referring to a war on terrorism, because the whole point about talking in terms of a war is not just that you conjure up a military ethos, but also that it has a beginning and an end. And this is not that type of situation. You are never going to be free of the threat of terrorism. There is always going to be some maniac with Semtex explosive or an assassin's rifle. Therefore, for the rest of time, we're going to be on our guard against it. That doesn't mean that we can treat each potential adversary, each potential military operation as simply a continuation of the last one. I think it also plays into another weakness, which is more a matter perhaps of Bruce's area of expertise than my own. The danger in talking about a war on terrorism is that it suggests that you have an enemy, the terrorist, or the terrorist organization. But terrorism comes from a wide range of different sources. If you go and talk to the British about terrorism, we'll talk to you about the IRA rather than about Al-Qaeda. As far as I'm aware, IRA and Al-Qaeda have nothing to do with one another at all. As far as I'm aware, Iraq, with its threat from weapons of mass destruction, is an entirely separate issue from Al-Qaeda. And there is, I think, a danger that the Cold War having come to an end, we are looking for an adversary similar to communism, some large, grand enemy, the antithesis of ourselves, the Antichrist, to go out and fight. And it's simply not that sort of world.
Joe?
just picking up on what Chris just mentioned, William James wrote an essay at the beginning of the 20th century called The Moral Equivalent of War. And what he was getting at in that essay was this idea of a cause that could mobilize a democratic society behind an issue, war on poverty, and similar phrase of a war on fill in the blank. I think the question does remain what sort of a war this really could or should be. And is it just sort of a political rhetoric in a sense to mobilize people behind a certain activity? There's also the question of if you have the specter of a war without end. From a security point of view, you also have a war without a perimeter. I mean, this is not a war in a classic strategic conception of a military battle. So that's another concern, and that brings up the question of whether war is the right lens and whether it should be seen more in terms of policing. This gets back to the questions of law. So it is a sort of a first order question of how to think about whatever it is.
Bruce, any comment?
It's interesting, there's going to be, Congress is putting together a committee now to look at the questions sort of a la Pearl Harbor. What do we know, when do we know it, and what should we have known? And that can go in a very bad political direction, but it also can be very useful. As Scott mentioned, I was working as one of Vice President Gore's foreign policy advisors in '99. I was there at the bitter end through 2000, which is a longer conversation. But it was very important because during that period, and every time there's a presidential election year, all these commissions form to write reports about what the new administration should do. Well, one commission that formed in 2000 was called the Commission on National Commission on Terrorism, and another was the so-called Hart-Rudman Commission. Gary Hart, Warren Rudman, the former senator, is bipartisan. The Commission on U.S. National Security in the 21st Century. Both of those reports, published in 2000, early 2001, made the argument that the single most dangerous threat to American national security is catastrophic terrorism. And I spent a lot of sessions with them, as did representatives of Governor Bush, talking about this. And so their websites became extremely popular, but the copyright date of the publication. So in one sense, this has been part of the context that we were not paying attention to until September 11th. There are some important questions there about thinking about why that are not finger-pointing questions. In that sense, I think that it needs to continue. I don't want to be too semantical, but I'm reasonably comfortable now with the notion of war on terrorism with a small w. Because I think that it defines an effort to try to focus. I'm not comfortable with the way it's gone about to forget about the September 10th agenda, because I think they interrelate. When will we know that we won? It's like, when would the threat of nuclear weapons go away once they were invented? I think we can know when we're winning, when the arrow's pointed in the right direction. Some of that will come from successful policies, we broke up this cell and we've broken up this financial network. Some of that will come from the further delegitimization of exactly what Chris said, this norm of one man's terrorist is one man's freedom fighter. The stronger and stronger the delegitimization of violence used in those ways gets in the international community, we've got a long way to go on that, and that's part of winning. And some of it, I think, without leaving out the IRA and others, does relate to some very fundamental issues in the Islamic world, some of which have to do with the peace process, and some of which go broader than that. When there can be wider political space, as it were, in Arab countries, I think that will also be part of it, so that there's less availability of people to move to terrorism. So I think there's signs about when we're winning, but I think that's as far as I go.
Bruce mentioned the Commission on Terrorism. I'll point out that Suzanne Spalding, who was the staff director of that commission, will be joining us later on the panel tomorrow morning on Homeland Defense. With that having been said, let me open it up to questions from the floor, and I would ask you again, Brian has the wireless mic. If you can wait until he reaches you, identify yourself and speak loudly. Yes, sir. Brian.
My name is Alan Buchanan. I'm a fellow at the National Humanities Center. I'd like to pick up on two things that Bruce said and see how the other panelists react to my elaborations of them. He said we need to integrate the post-September 11th agenda with a pre-September 11th agenda. I think that's extremely important. Part of the pre-September 11th agenda was the problem of ethno-national conflicts and in particular secessionist wars. I don't think that either the United States or the international community have come to a coherent, principled, proactive approach to secessionist conflicts. And this leads me to the second point that Bruce made that I want to emphasize. The dangers of new Cold War-like behavior, troops in the Philippines, troops in Georgia, troops in Yemen, possibly support of governments that are repressing what might be legitimate secessionist movements, for example, in Chechnya. And I think we're really on the road to ruin unless we go back and attend to unfinished pre-September 11th business of trying to develop a coherent, principled, proactive approach in international law and in U.S. policy towards secessionist conflicts. Because otherwise, to try to develop a doctrine of the use of military force without having sorted those normative issues out, I think is to really court disaster with regard to the second kind of activity that Bruce talked about, namely using the war on terrorism as a way of getting involved in lots of different countries where certainly we'll be suppressing some secessionist movements which may have fairly good claims to doing what they're doing.
Okay. Any responses to the comment? Not a question, but a comment. Chris?
Yes. I couldn't agree with you more about what you say about integrating the pre and post 11 September agendas. There isn't, in fact, a separate agenda. The world didn't change on the 11th of September in the way in which it's fashionable to talk about it changing. The problems of the Middle East, Kashmir, Cyprus, the border between Peru and Ecuador, none of those are any different on September the 12th from the way they were on September the 10th. It's just that this has what happened on the 11th of September presents a sudden new realization of a new and horrific form of warfare. So it would be madness to turn our backs on what was going on before and pretend that we can disregard it. The other thing that I think is tremendously important is not to fall for the trap of saying, well, the 11th of September presents such a novel form of threat that we've got to start all over again. We've got to rethink from the beginnings of international law. That's the luxury which, as an academic, we might have. But when I'm a practitioner, I've got to go and advise clients what's lawful today, what can we do at the moment. We can't reinvent the wheel every time a new problem comes up, and then having reinvented it 5 years on, go and present it to the policy people. We've got to deal within the framework of the existing military possibilities, the existing rules of law. What I try to show is that those rules of law are actually quite adequate to meeting that challenge.
I would just ask actually a question for Chris, which is, and maybe to Scott, which is, my understanding based on Alan's question is that the standards in terms of international legal standards or even normal standards for secession and wars of secession are unclear, and that's a place where the law needs to evolve. Is that sort of the basis?
I think so.
I think we'd agree.
Yeah.
But and I think, as Chris has said, the law is a constantly evolving process, and that's why in the international law you have the duality between treaty law and also the customary international law, which does reflect the practice of states.
I would just say one quick thing to Alan. I'd sort of tilt myself back a little bit the other direction. I agree with you, but something like Abu Sayyaf still needs to be dealt with. And the question is, how can that be done in a way that doesn't compound the political dimensions of the problem, but to a certain extent, in a classical, coercive sense, acknowledges that this is part of the network that is planning to is part of the whole network, and that's the tough balance that needs to be struck. I share some of your concerns about the way we're doing it, which I think is a little slippery slope.
Yes, sir. Front row.
Ed Clemmer, United Nations Association. We tend to think of two opposing methods, perhaps military force or war versus diplomacy, negotiation, compromise. Is there not a third method, a method that has eliminated defeating polio, a method that will largely predict how people vote in the next election. This great research institute of Duke, how about using objective scientific research on the causes of whatever it is we're trying to solve, in this case, conflict and terrorism?
I think it's just saying, that in the 90s, both in academia, the CIA set up a state failure project trying to look at, what are the factors that lead to state failure, demographic, environmental, economic, on and on. And I think they must have identified about, 86 crucial variables. But how to determine how they play out in different situations, I think, is not something that's susceptible to scientific analysis. It's susceptible to analysis. I think it comes back a little bit about where politics is an art, policy is an art, not just a science.
On this side, Mark?
Mark Weisberg, Law School, University of North Carolina. This question is primarily for Professor Greenwood and Dr. Rosenthal. One of the things that has happened since September 11th, certainly in reaction to the initial American bombings in Afghanistan, and also, of course, in reaction to events in the Middle East, has been tremendous concern with respect to non-combatant casualties. Now, I hope it's uncontroversial that humanitarian law imposes stringent limitations on military operations with respect to this question of non-combatant casualties. However, in some of the debate, one gets the impression that the position is being taken that there is some sort of some level of obligation to avoid any non-combatant casualties, and that any sort of an explanation or justification for particular occasions when such casualties occur is inherently suspect and both legally and morally illegitimate. I would appreciate it if you two gentlemen could address this question of the way of dealing, both legally and from a normative perspective, with this issue of non-combatant casualties, particularly in situations where at least one of the contending sides may well not be wearing uniforms and may be difficult to distinguish from the non-combatant population.
Well, thank you. I think the law on this is relatively clear. Civilians and civilian objects are not legitimate targets in their own right. That's proposition one. Proposition two, in attacking a military objective, something which you are allowed to attack, you've got to take whatever steps are reasonably open to you to minimize civilian casualties and civilian damage. The idea that there is an absolute obligation not to incur civilian casualties is nonsense. Unfortunately, I think it is a nonsense which, to some extent, the military plants this idea with two great PR errors. The first is the attachment to language like collateral damage, which is going to stick in a lot of people's throats, referring to a lot of dead women and children when you've blown up a hospital or a school as being collateral damage, I think is an unfortunate choice of words. The second is that we tend to brief everyone that we have got the smartest bombs. We have missiles so bright they can stop at the traffic lights. They're fired by the cleverest people, and therefore nothing can possibly go wrong. My experience of warfare has been entirely as an outside observer, but I can't think of a single conflict in my lifetime where, however sophisticated the army in question, they haven't managed to hit the wrong thing from time to time. It's inevitably going to happen. I think we've got to try and avoid this raising of expectations with too high a briefing about what's capable of doing.
I would just add, Mark, I totally agree with Chris, but from my experience in the Persian Gulf, that military commanders in general do do not believe they can use as much force against particular targets as international law clearly allows them to do. And the law requires not an absolute protection, but a balance between the military objective and the gains from the military objective as against the incidental damage that it might cause. Now, I think the military folks here know full well that in targeting decisions, whether we're talking Persian Gulf, Kosovo, Afghanistan, or anywhere, that a military commander in making that decision relies on a host of advisors. He is the decision maker. A host of advisors, including lawyers who are well versed in international law. And the famous incident involving the possible targeting of Mohar Mohammed Omar on 7th of October gave rise to that visibility of the team that advises the commander before you fire. But clearly there's a misperception that, that somehow either through precision-guided munitions or targeting decisions that there is an obligation to avoid any damage other than the military objective. And clearly the law does not say that. Yes, in the back, one of our students here represented.
My name is Pat McLean. I'm a student at Duke Law. I was wondering if the panelists could comment on the question of the use of force against Iraq, because it seems like the debate has centered on Saddam needs to go, can we do it? And if we can, let's do it. And if international law lets us, that's fine. And if not, who cares? So I was wondering if you, it seems a much more muddled case than Afghanistan. And I don't think there's any existing international law precedent that would allow the U.S. to use force. But I was wondering what you guys thought, and if there's a failure on the part of the UN Security Council to identify an obvious threat to international peace and security, is there some sort of subsidiary right inhering to individual states to take reasonable action to address that threat in the failure of the Security Council?
So let me stir the pot a little bit here. I start from premise that Saddam Hussein has been developing weapons of mass destruction. I actually had written a book. One of my books was about U.S. relations with Iraq in the period from the late 70s to the start of the war. It's called With Friends Like These, Reagan, Bush, and Saddam, 1982 to 1990, and it basically shows how, as we tilted towards Iran in the 80s, we and the Europeans, in the enemy of my enemy is my friend calculation, basically, blinked at a lot of efforts by Saddam, not only to withstand Iran, which is understandable according to that, but to develop, to acquire the technology and the materials for WMD. He used chemical weapons against the Kurds in 1988, the United States Senate, in one of those votes that was co-sponsored by Jesse Helms and Ted Kennedy. Not easy to find, 98-0 vote, voted to oppose sanctions. They were resisted by the Reagan administration for Iran reasons, agricultural export reasons, and the like. We found out that the enemy of my enemy may also be my enemy too, is basically where we took that. So I actually feel, that, and here, I'm not a lawyer. My perspective on international affairs, someone who is more on the policy side and is political science is that it's still partially Hobbesian, and that international law only takes us so far. And so I don't have any fundamental problem with the notion of, would this be an action in the interest of the United States and others in the international community? My biggest problem is with the how question, okay, particularly in the current context. In other words, it's a net security calculation to me. Do you end up more secure or less secure? And I have a feeling Ambassador Fahmy will speak to this as well today. I think you end up, dangerously less secure if you were to take such action. But I want to distinguish that calculation. If you could convince me of a net security positive, I at least, would be supportive of that. So I pass it along.
Yes, I think the truth of the matter is that finding a legal justification for a use of force against Iraq in the space of the next few months is going to be exceptionally difficult. I'm not saying it can't be done. It's possible that you can build it around the concept of anticipatory self-defense if there is sufficient evidence of an imminent threat. But for heaven's sake, let's be aware that if we do this, we've got to have a clear idea of what we're going to put in Iraq afterwards. And be under no illusions whatever that there is waiting in the wings a nice liberal democratic, or if you prefer, liberal republican, potential administration just waiting to come in with a bicameral legislature and elections every 4 years to take over Iraq. It's never had that sort of government in its history. The nearest it came to liberal government was during the 10 years when the British ran it as a colony. Likewise, don't imagine that it can be done with the full and enthusiastic support of the allies from the Arab world who supported us back in 1990 to 91, because it won't be. And the idea that worries me most is that we will invent a legal justification, thinking that we can go in there and in the space of a few weeks do a sort of Clint Eastwood job. We remove the bad. You've seen the film before. John Wayne made them probably rather better in black and white a generation earlier. You ride in, you get rid of the bad guys, and then the villagers clean up afterwards. If we decide to overthrow Saddam Hussein, we're taking on a responsibility for Iraq, which we're going to be looking at for decades, and which will dwarf Afghanistan, Kosovo, Bosnia, and any idea of sending 150 troops to the Philippines or anything like that.
I would agree with what both panelists said. Just add one small detail that gets back to what I had said in my prepared remarks about one big idea, this war on terrorism. I don't have any problem with what Bruce was saying about it's possible making a case anticipatory self-defense and so on. It depends on what the intelligence shows, I don't know, and so on, what the threat really is. But there does seem to be a conflation between a lot of things. I don't understand the connection, particularly between Al-Qaeda and Saddam and so on. Maybe those connections are there, maybe they're present. But there does seem to be one big idea right now, and Iraq seems to be part of it. And I'm not sure that's really where we should leave it. Maybe we should ask some more questions.
I would only add, Pat, since you mentioned Pat's, you finished your article on this very topic for the Journal. When we talk about expanding international law to encompass a lower level of threat to justify our time, I would only remind us all that the tool we craft in doing so is not one for us alone to use. And that is always the danger, creating new policies and moving the law to another extent that we assume that it is a vehicle for us. It is a vehicle for any country large enough and powerful enough to use. One more question. Randy.
Hi, my name is Randall Cook. I'm a student here at Duke Law as well. And I actually have a two-part question, so I'll get two for my bang. But the first follows up on Professor Silliman's comments at the end. I believe that it's a fair characterization of international law, at least since the formulation of the UN Charter, that the idea of preemption or preemptive strike was antithetical or unlawful under public international law. And yet, all three of you have referred to the idea of preemptive self-defense or anticipatory self-defense as an acceptable action in the context of September 11th. So are we seeing a change in international law towards the acceptance of preemptive strikes in certain contexts? And second, at least in the American political and constitutional context, the characterization of the state of affairs that exists in regards to terror is significantly affected by whether or not we describe it as a war. Specifically, the relationship between the president and his ability to enact achieve certain policy and procedural ends, such as the military commissions. Do you gentlemen feel that the concept of war is an anachronism in the international legal context, in the American constitutional context, and that therefore what we see today gives the president the full scope of his constitutional powers to essentially pursue the national interest in self-defense? Thank you.
Randy, one could teach a course on either one of those. But let me allow our panelists to hopefully briefly comment. Chris?
All right, brief comments on both of them. First of all, you have to distinguish, I think, between preemptive uses of force against a threat which is some considerable way down the line, and the use of force in response to a threat which is imminent. And of course, the concept of what is an imminent threat will vary depending on whether you're talking about regular armed forces, tanks rolling across the border, or somebody with a bomb in a suitcase, or planning to hijack an aircraft. I think the concept of imminence is broader in the latter case than in the former. But the right of anticipatory self-defense against an imminent armed attack was well established in customary law before 1945. And although the majority of writers say it disappears in 1945, that hasn't been the practice of states. And one of the things you have to recognize as a professor of international law is that customary international law is what the states make, not what I say. As to your second point about the US constitutional implications, first of all, the US Constitution's concept of war is not the same as international laws and never has been. It isn't even the same from one day to the next within US law. There are two fascinating cases in the US courts about whether Vietnam was a war for constitutional purposes. In the first case, for the purposes of jurisdiction of a court-martial over a deserter, the court said yes it was. In the second case, for the purpose of court-martial jurisdiction over a civilian who'd been selling quartermaster stores, which seems to be a phenomenon you get in any army in wartime. He'd sold 36,000 car batteries to people in Vietnam. They're still driving around. The court said no, it's not a war, because the deprivation of the right to jury trial has constitutional implications which only Congress can address. I think if you look at the actions of the President since the 11th of September, however often he's talked about a war against terrorism with a small w, he certainly hasn't treated it as war for the purposes of US constitutional law, not least because he didn't go and get a declaration of war out of Congress.
Any other comments?
Just two quick on the first one on this question of anticipatory self-defense. I think that's a classic case, though, of where the law is, I think Bruce said it in his phrase, gets you only so far. We have the principle, and then we can argue about that principle. It's not clear exactly how that will work out, and that's, I hope, where some notion of ethics kicks in. So when we're arguing about principles, we can anchor to some more values as well. The other is just on the Constitution. I think that President Bush, obviously, for obvious political reasons, again, Bruce would have more to say about this, but it's in his interest in the sense to just have it seen as a war for power of the executive over the legislature to maximize flexibility and ability to act quickly. So I think that there is some domestic political, what that means constitutionally, I think it's a long story.
Yeah, I would also just quickly on your first question. I mean, to me, it gets at not just questions, legal questions, but the broader, the hedgehog idea I like to see take hold is notions of prevention. You know, in the same way that there's been a lot of efforts in the medical and public health community to think broadly about prevention. And I think that that's absolutely crucial to any issue that you could possibly raise, from the global environment to global public health to ethnic and civil conflicts. And so I encourage you actually to look at this Responsibility to Protect report from the Commission on Intervention and State Sovereignty, because they talk there about how, again, this notion of force as possibly an early resort, not necessarily a last resort, and a little bit of the logic sometimes it takes you back to the old peace through strength arguments, that it may make it less likely you have to use it if it's a credible threat. So I think that if your goal is the goals as in the Universal Declaration of Human Rights, as in the UN Charter, there's got to be some anticipatory, preventive, preemptive kinds of concepts there, and it raises issues of limits. Your second question, again, I don't know the legal aspects, but part of my sense is that the political system actually can work. You know, I'm not an expert on the military tribunal issue, but my sense is that the way the press got a hold of it forced the administration to at least change somewhat where it was headed with that. The system worked when it was allowed to work, when the press was able to get access to the information it needed. The Congress, I think, can play a useful role in thinking about strategy if we can overcome some of this fear of being soft on and make the system work. So I actually think that the system can work. if we let the dynamics of checks and balances, separation of powers, freedom of the press really play themselves out, and don't overly constrain them with, with this notion of, applying to the domestic sector, you're either for us or you're against us. That can be very dangerous.
Gentlemen, thank you. Thank you for your questions. Join me in thanking the panelists for their